No, I think that's very good points, and I think it gives me a good segue to my next section, uh, because checks and balances, especially when there are corruption allegations or even the source of money issues, are very important. And funders would not like to be involved in cases where money is being used for uh, influencing the decision, not through the regular mechanism of litigation, but through other sources of influence. And no funder would like to be involved in it. Abhinav, ICC, of course, is a well-known name and does a lot of international arbitrations, and they surely must be seeing a lot of uh, cases involving funding. You, of course, are integral part of the Asia team, and you see such cases on daily basis. How do you keep checks and balances from an institutional standpoint to these crucial things like corruption, or what the funder is doing, what is their source of money, or if everything is hunky-dory, or do you not decide to keep checks and balances on these elements?
Thanks, Prateek. And thank you also for inviting me to be a part of this excellent initiative, which I'm sure will go from strength to strength as we go along, educating and self-controlling, regulating ourselves as far as India is concerned and litigation finance is concerned. Now, insofar as third-party funding is concerned, the question of third-party funding, and we've been talking about it more so in the last 3 or 4 years. When I was at the ICC in Paris, the first case that I got to know about third-party funding was in 2012. At that point in time, nobody was talking about third-party funding, conflicts, disclosures, and so on and so forth. The first time, I think it was in 2014, the IBA guidelines addressed this issue in their section 6B. And then immediately after that, we followed it up in our note to the parties and the tribunal on the conduct of arbitration. In the 2016 note, what we said was that, look, relationships between arbitrators, as well as relationships with any entity having a direct economic interest in the dispute, should be considered in the circumstances of the disclosure. So if any party has any economic interest in the dispute, that party should come out and that party's name should be disclosed. Similar, the suit was followed by other institutions, just to give you a perspective as to how institutions have evolved with respect to third-party funding. In 2016, CAM-CCBC came up with a similar provision. SEAC in 2017 came up with its practice note, and then in its investment arbitration rules in the same year. And finally, in the new 2021 rules, we've actually made a specific explicit provision where we've added the new paragraph in Article 11, which is the little 7 of Article 11. And we've said that in order to assist prospective arbitrators and arbitrators in complying with their duties under the articles so and so, each party must promptly inform the Secretariat and the tribunal and other parties of the existence and identity of any non-party which has entered into an arrangement for the funding of claims or defenses under which it has an economic interest in the outcome of the arbitration. So what we've done now is we've mandated and put an obligation on the parties to tell us and the arbitrators and the parties as soon as they know about the involvement of a funding arrangement. Even ICSID, I believe, in its latest revision of the rules has included the TPF regime and the new guidelines. And we obviously know there are at least 2 national legislations, that is Singapore and Hong Kong, that have adopted the third-party funding provisions in the legislations. Also not very alien to us are some bilateral investment treaties, which explicitly talk about disclosure obligations in the funding arrangement. Now, why is this important from an institutional standpoint? And I think the answer is the conflict of interest. Because arbitration rests on this fundamental, basic tenet of neutrality, independence, impartiality, the new entrant, which is the funder, these basic tenets in the institution's point of view must also equally, if not more, be applicable, should be applicable to the third-party funders. And to be very honest, there are reasons for that. And the reason is, look, today, a number of leading arbitrators have taken positions within or ad hoc consultant roles with some funders. Today, funders are occasionally approached directly or indirectly by arbitrators or arbitration experts to give advice. Increasingly in third-party funding, a concentrated segment of the funding industry invests in international cases, and there is a symbiotic relationship between funders and a small group of law firms which have related links among other law firms and some leading arbitrators, which then creates arbitration conflicts. All of this, when combined, calls for an increased transparency in third-party funding. Now, generally, the principle is that people should tell as soon as they know. However, what we've seen in practice, Prateek, is that we have seen tribunals order parties to disclose the funding arrangement. What we have not seen yet, but there are some cases, is to disclose the funding agreement. So, however, to give a famous example of, and also, I mean, funding agreement is not in dispute in most of the cases. However, there are instances where the funding agreement has been in dispute. I'm going to talk about it perhaps later. In the ICSID case, the famous Eurogas and Belmont Resources versus Slovak Republic, what happened was that the tribunal ordered the claimant to reveal the identity of its third-party funder for the purposes of checking for arbitrator's conflict of interest. But it did not require or order the claimant to disclose any terms of the funding agreement. But in that case, the claimant had previously and voluntarily, I must mention, it had disclosed that it was funded by a Luxembourg-based funder. But the claimant did not disclose the identity of the funder, and then the tribunal in its order asked claimant to disclose. And now we are seeing that more and more as we go forward, that the funding is almost become mandatory to disclose as soon as people know about it. And these are some of the stop checks and balances, because what from an institution we need, from an institutional point of view, what is extremely important is that the process remains completely unbiased, independent, and impartial.
Well, very important points, Abhinav, you make, and I think we need a rejoinder from the funders in the room to this institutional perspective, because, of course, our experience has been that unless mandated by regulation or rules, the general preference in a litigation finance context is to keep the secrecy. And Abhinav raises these points, especially I think an important point here is the point relating to funders having arbitrators or such other adjudicators as part of their decision-making system. What are your views, Tom, maybe Alan, maybe Sindhu? What are your views, or Dilip, as a matter of fact? How should we approach this delicate balance? Because Abhinav's right, there are a lot of funders who use those services. Should they not be maintaining transparency? Who would like to take this?
Prateek, I can comment quickly on that. I think practice is divergent across the industry and amongst funders. Our approach at Omni has always been a transparent one. We typically don't have an issue with having our involvement disclosed in the context of an arbitration. And I think what turns funders off sometimes is the concern that they may then be questions around security for costs that may be raised in response to disclosure. We have means of dealing with that in a simple and effective fashion, so we're less concerned about that. And what I would say is that international large funding organisation like ours has so many touch points around the world with different international law firms, with different arbitrators, and different parties that are involved in disputes, that it is possible for conflicts to arise, and the safest thing to do is to disclose and deal with those if there are any issues. Better to do that than have them arise later on and potentially undermine your reward. So that's at least our view, and I appreciate others have a different approach to that.
Any different approach in the group? Alan?
Oh, yes, I am on the same page as Tom. I think transparency is good, and the third-party funding has too much suffered of this I think a biased image. Transparency is very good, and we have nothing against having our presence rebuilt. Just there is an edge between this kind of transparency and to which extent certain information are taken by the opposing party to construct a strategy, and then it's not sound. And I think that if the IALF does a good job, and third-party funders, professional third-party funders belonging to the IALF and having the sound mechanism that we are thinking of, then the mere fact that the tribunal knows that one of these funders is there is of comfort for the tribunal, because it will be a clear mark that the origin of the funds is sound, and that there is no bias or illegal mechanisms, etc. And then transparency is just good.
And is that common sentiment with Sindhu, Dilip? Anything to add to this factor?
No, I think I'm very much agreed with what Tom and Alan are saying. I think it's important, to the extent that it's important to ensure the arbitrators are conflict-free and the funder's identity needs to be disclosed for that purpose, then absolutely that's the right thing to do. I think where some funders may get concerned is where that sort of leads to the funding agreements and the commercial terms of the same being scrutinized, and not just scrutinized, but being used strategically by the other side in sort of satellite disputes. And to the extent I think tribunals and judges regulate that, and they are getting better at regulating it, I think that would allay the concern significantly.
Right.
Just one second. I wholeheartedly agree with my colleagues, and I also agree that, look, disclosure of a funder's presence, I think to some extent is probably necessary. Funding terms are a little bit more sensitive, clearly. And Pratik, I think for us as IALF, as we go forward, it'd be interesting to look at different regimes around the world. In Canada, in Ontario, the lawyer has to apply for permission from the court for a funder to come into the action. And the court actually sets the funder's return within certain limits. So we're all for it.
Great. So I think the sentiment is common then, and Abhinav's concerns are then rightly noted by the institution. It's good to hear that there is movement from how litigation finance was looked at the past, as Alan said, in the garb of secrecy, because even in India, that is the reason why litigation finance got a bad name. It was a money lending business. It had certain form of secrecy. It used to be revealed at the end. There could be conflicts which would come in. And I like what I'm hearing, that people are taking it more in the modern way. And I think that's the good change which will bring in acceptance. We have two thriving practitioners with us today who are big names in the dispute resolution market in India.
Just before you go there, can I just add a very small addendum? In the age
Sure.
of transparency, there is a playroom as to when the disclosure should be made, at what stage the disclosure should be made. And I think the general rule there is that, look, the identity of the third-party funding arrangement or the funder to the arbitrators or the institution should be made as a part of the first appearance or submission. The later you do it, the more complicated this gets, because by that time your time, energy, resources are invested. It seems quite obvious, but I think there is a hesitation in the beginning to disclose it. And I think it should be done as quickly as possible so that these stumbles are blocked. And if there is a disclosure and there is a conflict, then let the arbitrators and let the institution then take the right call as to what best can be done to mitigate that disclosure or the effect of it. Thank you.
Yes, Abhinav did get his Sir rejoinder, and you would see those applications from Indian lawyers very often. We like to have the last word in the debate. Very, very happy to give Abhinav that chance.